Folks, it will come as no surprise to you that the Chicago Police Department has major issues. Issues in how it deals with various communities, and let me just call it the way it is, dealing with the black community and more than likely the Hispanic community, though we don't hear a whole lot about abuses in the Hispanic community, problems with its use of force, and you've seen constant videos regarding police officers straight out killing black citizens in Chicago. It has a problem with one particular police quote-unquote station, which is known to most people familiar with Chicago as a black site, where you go in but you may not come out, and you damn sure aren't going to come out in the same condition that you went in there with. So look, the Justice Department went in and did a report on the Chicago Police Department, and today they issued that report. Now, I'm going to play this clip for you from MSNBC. Then I haven't had an opportunity to read the report. I am going to read the entire report and then come back to you on this video with my opinions regarding the information within the report, and then make a comment regarding overall policing in this country. But here is the clip from MSNBC.
On MSNBC, the other big story that we're following at this hour, the Justice Department's scathing report finding widespread racial bias and unconstitutional policing in the Chicago Police Department. The DOJ's 13-month-long investigation was prompted by the release of the shocking video showing a white police officer fatally shooting 17-year-old Laquan McDonald as he appeared to be running away from police during a pursuit. Chicago's Mayor Rahm Emanuel initially resisted calls for a Justice Department investigation of the police department. NBC's Gabe Gutierrez is joining us now from Chicago. Gabe, this was kind of striking to see Loretta Lynch there standing before the cameras making this assessment today. What does it ultimately mean for the Chicago Police Department right now and moving forward into the future?
Hi there, Peter. Good afternoon. Where there are many questions regarding that, considering that the Trump administration will be taking over, and its nominee for Attorney General, Jeff Sessions, has said that he's not a fan of using federal courts to bring about local police reform. The local Fraternal Order of Police, the head of the FOP, is also calling this a rush job. But let's take a look right now at some of the things found in this report, if we can put those up. Attorney General Loretta Lynch said that there was a pattern or practice of using force, including deadly force, in violation of the Fourth Amendment by the Chicago Police Department. Also, a failure to collect adequate data to determine whether force was used correctly, and that there was low officer morale and low officer accountability, and also severely deficient training within the Chicago Police Department, including that during the police academy, some trainees were viewing training videos that were in some cases decades old.
Now, I will submit in that area where it said adequate data, I submit that that's not the right word. I submit that the correct word is correct data. Okay, because there's data, okay, i.e. reports, but as if you're not aware, there are so many falsified reports that it is a sin against nature the way that some of these reports are written, covering up for the various crimes of police officers, etc.
During the course of our investigation, the department heard from countless officers who were themselves disillusioned and discouraged by strained trust. by inadequate training, poor oversight, and inattention to officer wellness and safety. And those officers are proud to wear the badge, but they recognize that they lack the support, both from the community and from the city, to properly do their jobs. And they understand that repairing trust with the communities that they serve will require difficult and meaningful reforms.
Okay. This piece that they're showing you now is propaganda. I submit that the most important part of the statements that she made are not even being shown here. She's coming at this thing from a the poor police perspective. What happened to the part about the poor community perspective as far as the police taking advantage and violating the constitutional rights of the citizens? So stories are always framed by the information or lack of inclusion of information. So, and again, I just took a fast look online. I hadn't read the report and getting ready to go do that right now. But the comments that have been made online by ordinary citizens like you and me have been and I do mean this, 100% negative on the two sites that I took a look at regarding the Department of Justice's report here. And they are looking to blame, okay, or negatively comment on the Department of Justice even coming in here and saying anything. I don't know, Donald Trump, that he has done something, and I don't know if that genie's going to be put back in the bottle. But okay, the next comments that I'm going to make are going to be regarding the report itself.
Now this morning, for the first time, Chicago Mayor Rahm Emanuel said that, for the first time, he said that the city had agreed in principle to begin negotiations on an independently monitored, court-enforced consent decree. Peter?
Gabe Gutierrez with what was a significant announcement out of Chicago today.
Hey folks, I just completed reading the investigation of the Chicago Police Department report done by the Department of Justice. The investigation began December the 7th, 2015. The report was completed January 13th, 2017. Now, I will say this. You could take Chicago out of this and you could take the Baltimore investigation, take the name Baltimore out of it, substitute Chicago for Baltimore, and you would pretty much damn near have the same report, okay? I submit that you could probably go into most major cities, do an investigation of the various big city police departments, and come up with the same damn report. So what does that tell you? It tells me that the police department basically is racist, prejudiced, and is used as a occupying force, especially in communities of color. Most of the information that you find in these various Department of Justice reports do not apply to the white communities, okay? They apply primarily to black communities, Hispanic communities, and probably, though I'm not totally aware of it, Asian communities. If you want to go a little bit further, if you interviewed Native American communities, you might, for the most part, find the same thing. I say that because I've seen various news stories throughout the years regarding the abuse by police, both the police on reservations and off reservations, of Native American citizens, a lot of them women. All right, I'm not going to do what I did the last time when I reviewed the Baltimore report. I went page by page on that thing. This time, I'm just going to try to target individual sections in order to try to keep this video down. The first section I'm going to jump to is on page 6, and I'm going to leave the link to this particular report, and you need to read the report for yourself, okay? I'm just saying that straight out. It's people like me that try to provide you with the information, but we as a people need to be informed, and every last one of us who gives a damn needs to read these reports so that we are armed with the information necessary in order to try to combat this, at least on a verbal plane, if not actually going out and getting with our local elected politicians and pressing them to get stuff done. And I'm going to say this report is just as ridiculous as that Baltimore report was. And it's my understanding that the city of Milwaukee is currently undergoing a Department of Justice review. And I'm not holding out a lot of hope for that one. Now, with that being said, I'm kind of glad that this one came out when it did, because if Jeff Sessions gets in there, he has stated his apprehension about doing reviews and committing to entering into consent decrees with various cities. Now, Chicago has agreed to go into negotiations on a consent decree, but they're not going to get that done between now and when President Trump gets sworn in and the Attorney General is also confirmed and sworn in. So as far as an actual consent decree for Chicago is concerned, honestly, I'm not holding out a lot of hope on that. All right, let's cut to the chase here. I'm jumping to page 6. And forgive me. Okay, here's page 6. Among the most egregious uses of force we reviewed were incidents in which CPD officers shot at suspects who presented no immediate threat. CPD's use of less lethal force also contributes to the pattern of unlawful conduct we found. We reviewed instances of CPDs using less lethal force, often tasers, including in drive stun mode, against people who pose no threat, and using unreasonable retaliatory force and unreasonable force against children. We also found that CPD officers use force against people in mental health crisis where force might have been avoided. These issues are further discussed along with specific examples in the fourth section of this report. CPD does not investigate or review these force incidents to determine whether its responses to these events were appropriate or lawful, or whether force could have been avoided. The city is currently taking steps to improve its response to persons in mental health or behavioral crisis, in part in response to the tragic shooting deaths of Quintonio LeGrier and Betty Jones. While we applaud the steps the city has taken as discussed in our report, there are important additional steps the city needs to take. The city must do more to ensure that effective, well-trained crisis intervention officers respond to these events, and that mental health or similar crises are analyzed to determine whether changes to the program or CPD's crisis response are warranted. We found many circumstances in which officers' accounts of force incidents were later discredited in whole or part by video evidence. Given the numerous use of force incidents without video evidence discussed in Section 2C of this report, the pattern of unreasonable force is likely even more widespread than we were able to discern through our investigations. So basically, what they said is that these cops are basically using force when it's not required, okay? They have no training or very little training in dealing with people that are having mental health crises, and they lie. Plain and simple, they lie. Now, let me go to page 7. Accountability. The city received over 30,000 complaints of police misconduct during the 5 years preceding our investigation, but fewer than 2% were sustained, resulting in no discipline in 98% of these complaints. This is a low sustained rate. In evaluating the city's accountability structures, we looked beneath these and other disconcerting statistics and attempted to diagnose the cause of the low sustained rates by examining the systems in place, the resources and leadership involved in the city's accountability bodies, including CPD's Bureau of Internal Affairs, IPRA, and the Chicago Police Board. That Chicago Police Board is a joke. They have no power whatsoever, and it's people running around basically neutered. We reviewed their policies and practices, interviewed many current and former supervisors, investigators, and other members involved, and we reviewed hundreds of force and misconduct investigative files from an accountability standpoint. We discovered numerous entrenched systematic policies and practices that undermine police accountability as described below. We also took into account that the city has taken many steps during the investigation to address many of these accountability deficiencies, including creating COPA, which will replace IPRA as the independent agency responsible for investigating serious police misconduct. Although we commend the city for these and other recent reforms, they do not sufficiently address many of the problems we discovered in the city's deeply flawed investigative system. The city does not investigate the majority of cases it is required by law to investigate. Most of these cases are uninvestigated because they lack a supporting affidavit from the complaining party. But the city also fails to investigate anonymous and older misconduct complaints, as well as those alleging lower level force and non-racial verbal abuse. Finally, and also contrary to legal mandates, IPRA does not investigate most taser discharges and officer-involved shootings where no one is hit. Some of these investigations are ignored based on procedural hurdles in city agreements with its unions, but some are unilateral decisions by the accountability agencies to reduce caseloads and manage resources. And many misconduct complaints that avoid these investigative barriers are still not fully investigated because they are resolved through a defective mediation process. That mediation process is not a mediation process. I'll go into that later. Which is actually a plea bargain system used to dispose of serious misconduct claims in exchange for modest discipline. Regardless of the reasons, this failure is to fully investigate almost half of all police misconduct cases seriously undermines accountability. These are all lost opportunities to identify misconduct, training deficiencies, and problematic trends, and to hold police officers and CPD accountable when misconduct occurs. In order to address these ignored cases, the city must modify its own policies and work with the unions to address certain collective bargaining agreement provisions, and in the meantime, it must aggressively investigate all complaints to the extent authorized under these contracts. Okay, translation, the unions, the police unions, Fraternal Order of Police, etc., are complicit in the behavior of its police officers and how the city signed off on contracts that allow police officers to get away with this, I call it criminal activity, is a shame. It's more than a shame. It should be illegal, and it shows the lack of morality and judgment of the city officials who sign off on these contracts that legally allow police officers to get away virtually with murder. Okay, guys, sorry, I had to go pick up the grandkids. Anyway, training and supervision. This is on page 10. I'm going to just read the second paragraph. Both at the outset and through the duration of their careers, CPD officers do not receive the quality or quantity of training necessary for their jobs. Big surprise. Pre-service academy training relies on outmoded teaching methods and materials and does not equip recruits with the skills, knowledge, and confidence necessary to serve Chicago communities. For example, we observed an academy training on deadly force, an important topic, given our findings regarding CPD's use of force, that consisted of a video made decades ago, which was inconsistent with both current law and CPD's own policies. The impact of this poor training was apparent when we interviewed recruits who recently graduated from the academy. Only 1 in 6 recruits we spoke with came close to properly articulating the legal standard for use of force. Post-academy field training is equally flawed. The field training officer program, as currently constructed, does not attract a sufficient number of qualified, effective leaders to train new probationary police officers, has an insufficient number of FTOs, field training officers, to meet demand, and fails to provide PPOs with appropriate training, mentorship, and oversight. Finally, in-service training is not provided pursuant to any long-term training plan or strategy. Instead, CPD provides only sporadic in-service training and does not think proactively about training needs department-wide. Without a long-term training plan, CPD is often called upon to deliver ad hoc training on tight timelines in response to crisis. Consequently, in-service training are often incomplete and ineffective at teaching officers important skills and information. The recently mandated department-wide TASER training exemplifies CPD's problematic approach to in-service training. Large numbers of officers were cycled through this important training quickly in order to meet a deadline set by the city, without proper curriculum, staff, or equipment. This left many officers who completed the training uncomfortable with how to use tasers effectively as a less lethal force option, the very skill the training was supposed to teach. Yep, so then it goes on into a couple other things. I'm going to jump to page 12, which is data collection. Data collection and transparencies. Our investigation found the additional steps are necessary to ensure the city as transparent as possible and uses its data to adequately address the patterns and practices identified in this investigation. The city and CPD must improve the ways in which they collect, organize, analyze, track, and report on available data and data trends. Currently, CPD's data collection systems are siloed and do not allow for meaningful cross-system data collection, evaluation, and tracking. As a result, CPD is unable to easily use the data at its disposal to identify trends, including trends in misconduct complaints, training deficiencies, and more. Improving these systems will allow CPD to better understand its operations and more easily report CPD activities to the public. The data that is collected and publicly reported by the city is also incomplete and at times inaccurate. IPRA reports only on how investigations are resolved by that agency, but as discussed in this report, the findings of IPRA investigators can be set aside and its discipline recommendations greatly reduced. IPRA's reporting, therefore, does not give a full picture of how misconduct investigations are ultimately resolved. All right, now I'm going to jump to page 13. That has to do with promotions. And as we all know, promotions, for the most part, can be dictated by who you know and who you blow. The report reads as follows. Despite these important reforms, whatever those are, officers we spoke to would continued to express skepticism about CPD's promotion system. Much of this is because CPD does not effectively communicate the details of its promotion process to the rank and file and does not provide sufficient transparency following promotional decisions to allay officer concerns. For example, officers are unaware of the metrics used to evaluate individuals who are nominated for merit promotions or why the officers receiving those promotions were selected. By not sharing this information publicly and not ensuring department-wide understanding of the promotion system, CPD has perpetuated an atmosphere of doubt around the promotion process as a whole. All right, let's jump to page 14, community policing. Notwithstanding this recognition, community policing as a true CPD value and driving force fell away in Chicago many years ago, and past attempts to restore it have been unsuccessful. To be successful this time, CPD must build up systems to support and bolster this community-focused approach to policing. CPD has the officers it needs to make community policing work. During our investigation, we observed many incidents of diligent, thoughtful, and selfless policing, and we heard stories of officers who police this way every day. We know that there are many dedicated CPD officers who care deeply about the community, are affected by the violence they see, and work hard to build trust between the community and the department. We heard about officers and command staff who are well respected and beloved in the neighborhoods they patrol. I would love to get a survey on the various neighborhoods throughout Chicago and to see which communities love their police and which communities had a less than stellar opinion of their police. Jumping to page 15, the city must address serious concerns about systematic deficiencies that disproportionately impact Black and Latino communities. Feeling is, their love for police is not going to be that high. CPD's pattern or practice of unreasonable force and systematic deficiencies fall heaviest on the predominantly Black and Latino neighborhoods on the south and west sides of Chicago, which are also experiencing higher crime. Raw statistics show that CPD uses force almost 10 times more often against Blacks than against whites. As a result, residents in Black neighborhoods suffer more of the harms caused by breakdowns in uses of force, training, supervision, accountability, and community policing. It goes on to say that a consent so that you can get a history of the Chicago police force. Okay, here's page 18. Historical background of reform in Chicago. The Chicago Police Department has cycled in and out of the national consciousness almost since its inception, and the last several decades have been no exception. In 1968, images of CPD officers beating protesters at the Democratic National Convention were captured and broadcast on national TV. A commission convened in the aftermath of the event found that the violence amounted to a police riot. Strangely, no officers were prosecuted. In the 1980s and 1990s, a CPD detective, John Burge, and several other officers under his command used severe interrogation tactics such as physical force, suffocations, and electric shock to coerce confessions from predominantly Black men living in Chicago's south and west sides. Burge was ultimately fired, and in 2008, decades after the abuse began, he was arrested on charges of perjury and obstruction of justice. He was convicted on all counts, but was allowed to keep his pension from CPD and served only 4.5 years in prison. And you wonder why we don't believe that justice is evenly meted out to everybody. In the 1990s, CPD ran a special enforcement unit within the patrol division called the Special Operations Section. This unit improperly stopped and searched Black and Latino community members and seized their cash and property. Many of the officers working in that unit amassed numerous misconduct complaints. When the activities of the unit became publicly known, it was disbanded, and several officers involved were arrested and sent to prison for robbery and kidnapping. More recently, the circumstances of several officer-involved fatal shootings have generated coverage by national media, including the deaths of Rakia Boyd, Laquan McDonald, Kentonio LeGrier, and Betty Jones. Now, I wonder if there's going to be any reference to that black site that they have in Chicago. I read through it, I didn't see it, but I'm going to scan through as we continue going through this thing. One thing that I did fail to mention, the Department of Justice, through various programs, here we go, federal involvement in Chicago. I'm not going to read all that, but just let it be known that the Department of Justice has a lot of programs, and it pumps tons, and I do mean tons of money in the Chicago Police Department. Now, as I stated earlier, December 7, 2015 is when the investigation began on the City of Chicago Police Department. This section that you're looking at basically tells you what they went in there looking for. Now, I'm going to jump to page 22. CPD engages in a pattern of or practice of unconstitutional use of force. We reviewed CPD's force practices, mindful that officers routinely place themselves in harm's way in order to uphold their commitment to serve and protect the people of the City of Chicago. That officers regularly encounter individuals who may be armed and determined to avoid arrest, and that our inquiry should be guided by the perspective of the reasonable officer on the scene rather than perfect hindsight. We likewise recognize that officers have not only a right but an obligation to protect themselves and others from threats of harm, including deadly harm, which may arise in an instant. We also recognize that the city has taken some steps that, if properly implemented, could represent meaningful improvements to the way that officers use force. Nonetheless, we found reasonable cause to believe that CPD has engaged in a pattern or practice of unreasonable force in violation of the Fourth Amendment, and that the deficiencies in CPD's training, supervision, accountability, and other systems have contributed to that pattern or practice. CPD has not provided officers with adequate guidance to understand how and when they may use force, or how to safely and effectively control and resolve encounters to reduce the need to use force. CPD often does not appropriately supervise officers to identify dangerous tactics or behaviors that may indicate officers need additional training or other intervention. CPD also does not review its force practices as a whole to identify problematic trends or patterns that endanger officers and others. When officers use force, CPD often does not adequately review those force incidents to determine whether the force used complied with the law or CPD policy, or whether the tactics the officer used were safe and effective. Consequently, officers are asked to perform a dangerous job with insufficient guidance as to whether their force practices are safe, effective, or legal. These failures have resulted in CPD engaging in a pattern or practice of using force in a manner that is unconstitutional, contrary to CPD policy, and unsafe. Inappropriate use of force by the police, even when no lasting physical injury is involved, results in fear and distrust from many of the people whom the police are committed to protect and whom the police need as partners in that effort. Now, here is the use of force definition by law enforcement officers as far as violating the Fourth Amendment. Court case Graham versus Connor, 490 U.S. 386, 394, 1989. In determining whether police used excessive force under the Fourth Amendment, the relevant inquiry is whether the officer's actions were objectively reasonable in light of the totality of the circumstances. Flournoy versus City of Chicago, that was 2016, citations omitted. Fitzgerald, there's various cases that they're citing. I'm going to skip those pieces. In determining whether force used by a law enforcement officer is reasonable, courts look to the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he's actively resisting arrest or attempting to evade arrest by flight. Whether a particular use of force is reasonable is judged from the perspective of a reasonable officer on the scene rather than the 2020 vision of hindsight. Courts are mindful that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. That is a very key section, so I'm going to read it again. Courts are mindful that police are often forced to use split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. An officer's use of force is unreasonable if, judging from the totality of the circumstances at the time of the arrest, the officer uses greater force than was reasonably necessary to effectuate the arrest. Later on, I'm going to read you a section regarding coaching, so remember this particular section and phrase that I just read to you. Jumping to page 24, paragraph 1. Although a specific number of incidents and statistical evidence is not required, our investigation found that CPD officers use unnecessary and unreasonable force in violation of the Constitution with frequency, and that unconstitutional force has been historically tolerated by CPD. This finding is based on a comprehensive investigation of CPD's force practices. We reviewed CPD's policies relating to the use of force, reporting, and the investigation of force, including older versions of policies that were effective during our review period, and CPD's proposed revised policies. We spoke with officers at all ranks, including the superintendent and the chief and deputy chief of the Bureau of Patrol, to understand how officers were trained to use force, their view on when force is appropriate, and how the policies are interpreted and practiced throughout CPD and at each level. We also did an in-depth review of officer reports of force, civilian complaints of force, and CPD and IPRA's reviews of force and investigations of allegations of excessive force. We reviewed over 425 incidents of less lethal force, including representative samples of officers' own reports of force and of investigation of civilian complaints about officer force between January 2011 and April 2016. All right, I'm going to jump to page 25, the last two paragraphs on page 25. It has to do with CPD's pattern of or practice of unreasonable force, including shooting at fleeing suspects who present no immediate threat. In some cases, CPD officers initiated foot pursuits without a basis for believing the person had committed a serious crime. In these cases, the act of fleeing alone was sufficient to trigger a pursuit ending in gunfire, sometimes fatal. During subsequent review, almost without exception, officers' reports of these events were accepted at face value, even where there was contrary evidence. In one case, a man had been walking down a residential street with a friend when officers drove up, shined a light on him, and ordered him to freeze. Because he had been fidgeting with his waistband, the man ran. 3 officers gave chase and began shooting as they ran. In total, the officers fired 45 rounds, including 28 rifle rounds towards the man. Several rounds struck the man, killing him. The officers claimed the man fired at them during the pursuit. Officers found no gun on the man. However, officers reported recovering a handgun nearly a block away. The gun recovered in the vicinity, however, was later determined to be fully loaded and inoperable, and forensics testing determined there was no gunshot residue on the man's hands. IPRA found the officers' actions were justified without addressing the efficiency of the pursuit or the number of shots fired. So there's a case, of total bullshit, but yet the officers lied, but their lie was covered up. Here's another one. In another case, a CPD officer chased and shot a man. The officer later claimed that during pursuit, she ordered the man to stop, at which point the man turned and raised his right arm towards her. According to the officer, a man had The man had pointed a gun at her earlier in the incident, and fearing he was going to do so now, she fired. The only gunshot wounds were in the man's buttocks. No weapon was found on the man, but a gun was found on a nearby roof gutter. IPRA found the shooting justified without accounting for the wounds in the man's backside. In another case, a CPD officer chased the man who ran when an officer told him to stop, and then shot the man in the back of the leg. The officer claimed the man had turned to point a gun. After a thorough search of the scene, no gun was recovered. The man, who denied ever turning to face the officer, was found only with a cell phone. I mean, they got tons and tons of these. Okay, I'm not going to sit here and try to read all of them. I'm going to jump to page 27. CPD's pattern of practice of unreasonable force includes firing at vehicles without justification. CPD's policy has long formally recognized the appropriate tactical response to officers facing threats from moving vehicles. Its deadly force policy for the period September 2002 to February 2015 provided, when confronted with an oncoming vehicle and that vehicle is the only force used against them, sworn members will move out of the vehicle's path. Since February 2015, CPD policy expressly prohibits firing at or into a moving vehicle when the vehicle is the only force used against a sworn member or another person. CPD did not enforce its policy, however. For example, in one case, an off-duty officer witnessed a reckless driver cause a vehicle collision during a high-speed chase. The officer exited his vehicle and ran to the scene. The motorist seeking to escape backed up his car, managing to pin it between the officer's vehicle and a tree. The officer moved in front of the trapped car and fired 2 shots into the windshield, claiming he did so because he heard the car's engine revving. During the IPRA investigation, the officer was never asked to explain why he positioned himself in front of the car or why he could not have stepped out of the way if he believed the car was about to move forward. IPRA found the shooting justified despite the apparent policy violation or insufficient factual record regarding the officer's claimed need to fire in self-defense. And again, I welcome you and advise you to pull this report and read it for yourself. I'm going to jump to page 28. CPD officers exhibit poor discipline in discharging weapons. We found repeated incidents where officers exhibited poor discipline in discharging their weapons, reflecting disregard for innocent bystanders and constitutional standards, as noted above. For example, in one incident, 3 CPD officers fired a total of 45 rounds, including 28 rifle rounds, at a man during a foot pursuit in a residential area. This man was shot several times, but dozens of bullets were fired into the residential neighborhood. I mean, it's crazy. CPD officers make tactical decisions that unnecessarily increase the risk of deadly encounters. They fail to wait for backup and use unsound tactics in approaching vehicles. Okay, let's jump to. They use dangerous vehicle maneuvers. They participate in reckless pursuits. This is all stuff that these guys do, but yet and still, they claim that it's always the actions of the quote-unquote suspect that create these situations when it's they themselves that are doing this. Now on page 32, there's a section which I'm not going to read. CPD uses less lethal force in violation of the 4th Amendment and department policies. I welcome you to go to download this thing and go to page 32 and read that one for yourself. I'm jumping to page 33. Check that. I'm jumping to page 34. CPD's pattern or practice of unreasonable force includes the use of excessive, less lethal force against children. CPD's pattern or practice of excessive force also includes subjecting children to force for non-criminal conduct and minor violations. In one incident, officers hit a 16-year-old girl with a baton and then tasered her after she was asked to leave the school for having a cell phone in violation of school rules. Officers were called in to arrest her for trespassing. Officers claimed the force was justified because she flailed her arms when they tried to arrest her, with no adequate explanation for how such flailing met the criteria for use of a taser. This was not an isolated incident. We also reviewed incidents in which officers unnecessarily drive-stun students to break up fights, including one use of a taser in drive-stun mode against a 14-year-old girl. There was no indication in these files that the student's conduct warranted use of the taser instead of a less serious application of force. Okay, so it doesn't matter if you're an adult or a kid. They're going to get in your ass. Now here's a good one. Page 36. Video evidence suggests a broader pattern or practice of unconstitutional use of force. Evidence suggests that the pattern of unreasonable use of force identified by our investigation may be even broader than that revealed through CPD documents alone. During our investigation, we reviewed numerous use of force incidents captured on video. In many of these incidents, the use of force was facially unreasonable, and the videos undercut the officer's description of the incidents. Given the large volume of reported incidents not captured on video, this suggests that the extent of unreasonable force by CPD officers may be larger than is possible to discern from CPD's scant force reports and force investigations alone. Indeed, the inaccurate description of events that were undercut by video we reviewed bore striking similarities to descriptions provided by officers in numerous cases with no video. In one incident captured on cell phone video, an officer breaking up a party approached a man, grabbed him by the shirt, and hit him in the head with a baton. In his reports, the officer used language very similar to that used in many other reports reviewed, falsely claiming that the victim had tried to punch him. Before the video surfaced, the officer's supervisor had approved the use of force and the of his police powers and is facing criminal charges for his conduct. In another video, a woman exited her car and placed her hands on her vehicle when officers threw her to the ground, hit her, and deployed a taser against her. The video indicated that the officers claimed that she had refused to show her hands, thus justified the force used, was false. Despite the existence of the video, IPRA deemed the force reasonable. See, the whole point of this is no justice. No justice. The videos don't lie, but it's these asshole police departments, unions, and even these police review boards that are stacked against citizens that piss people off and give people no confidence in the accountability of police. Sorry about that. All right, and there's a bunch more cases in here. I'm jumping to page 37. CPD does not effectively use crisis intervention techniques to reduce the need for force. You go ahead and read that for yourself because you know that is self-explanatory. All right, I'm going to jump to page 38. CPD's crisis intervention team model needs more support to be sustainable. This particular page gives a history of how they created their crisis intervention team. That's to be used when it's deemed that the person has mental health issues, etc., etc., etc. I'm going to skip past that because most police departments don't know how to deal with people that have mental illness. And that particular section just goes on to describe the problems with it, the fact that they need more training, etc. It also goes into analyzing the incidents to determine if they're functioning effectively, which we all know they're not functioning effectively. I'm jumping to page 41. CPD's failure to accurately document and meaningfully review officers' use of force perpetuates a pattern of unreasonable force. CPD policy requires officers to report most uses of force, but in practice, officers are not required to provide sufficient detail about the force they use, and most officer force is not reviewed or investigated, notwithstanding CPD policy requirements. In the most serious instances of force, where an officer discharges his firearm in a manner that could potentially hit someone, CPD responds to the scene to conduct a preliminary investigation, but IPRA has the authority to investigate whether the shooting was justified. Because of IPRA's central role in these cases, all aspects regarding the reporting and review of these uses of force, including CPD's initial response to the scene, is discussed in accountability. That's page 41. CPD does not require officers to accurately report uses of less than lethal force. CPD's documentation of officer use of force less than lethal force is consistently insufficient. Moreover, CPD and IPRA have accepted insufficient documentation even when officers' use of force is suspect or when people complain about the force officers used against them. You go ahead and read page 42. I'm going to jump to page 43, paragraph 3. This is a hot one. It also appears that officers have been instructed on the language they should use to justify force. We saw many instances where officers justified force based on a boilerplate description of resistance that provides insufficient specificity to understand the force used or resistance encountered. For example, officers frequently reported using force because the person flailed his or her arms. Officers used a taser against a man who appeared to be in crisis when he stiffened his body, pulled away, and flailed his arms. They drive-stunned the man because when they went to arrest him, he began to flail his arms wildly. They deployed a taser against the man who resisted arrest for theft by flailing his arm, and drive-stunned the man because when they tried to arrest him, he pulled away and flailed his arms. Okay, that's just one of them. You all know about the I was in fear for my life, etc., 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 right? That's or he was reaching. Commonly coached to always mention at least one of those three things. Sorry about that. CPD rarely reviews or investigates officers' use of less than lethal force. I had mentioned earlier that if shots are fired, but nobody's hit, very few investigations. If a taser is used and a person isn't seriously injured, a lot of the times these guys are not even filing reports. Now, they supposedly have a new de-escalation training policy, and that is mentioned in this report, stating that it should be expanded and sustained. I'm not going into that. Okay, let's go to page 46. Chicago's deficient accountability systems contribute to CPD's pattern or practice of unconstitutional conduct. Jumping to page 47. Our investigation confirmed that CPD's accountability systems are broadly ineffective at deterring or even detecting misconduct and at holding officers accountable when they violate the law or CPD policy. As with most complicated problems that have built up over time and repeatedly been glossed over, we found that many factors contribute to the systematic deficiencies of CPD's accountability system. These are summarized below. And I am not going to read all of that. That is on you to read, page 47. Jumping to page 48. Chicago's system for investigating police conduct. The IPRA investigates 4 types of complaints: excessive force, domestic violence, coercion, and bias-based verbal abuse. It also conducts mandatory investigations regardless of alleged conduct for officer weapon discharges, including gun, taser, or pepper spray, and 2, death or serious injury in police custody. Over the past 5 years, IPRA has received almost 7,000 citizen complaints per year and retained investigative authority over approximately 30% of them as falling within IPRA jurisdiction. In addition, it receives notification of approximately 800 mandatory investigations a year. All right, the rest of that, page 48, you can go off into that. I'm jumping to page 50. But I will say that the majority of those complaints are not even investigated. All right, the city has unduly narrowed the scope of misconduct allegations that are fully investigated. Now, let me back up. I just saw something that I thought was pertinent. The city has put in place policies and practices that impede the investigation of officer misconduct. City policies and practices prevent investigation of a substantial portion of CPD misconduct complaints and uses of force, including many it is required by law to conduct. Deficient systems and police culture inhibit many other complaints of police misconduct from ever being filed. These deficiencies keep unconstitutional conduct and practices hidden. We discussed below several of the unnecessary barriers to investigation, including a formal policy against investigating many complaints about force, referral of verbal abuse complaints to a process in which no discipline can be imposed even if misconduct occurred, a failure to investigate anonymous complaints or complaints without a sworn affidavit, and handling many complaints via a so-called mediation process that is in fact antithetical to the tenets and goals of complaint mediation. Collectively, through this patchwork of policies and practices, the city fails to conduct any meaningful investigation of nearly half of the complaints made against officers. This is separate and apart from CPD's failure to investigate most of the taser and no-hit shootings required under law, or to conduct any review of the vast majority of officer uses of force that are disclosed in the 4th section of this report. Now I'm going to jump to the portion where the city unduly narrows the scope of misconduct allegations that are fully investigated. One way in which the city has acquiesced to narrowing the scope of misconduct complaints it investigates is through the police union contracts provision requiring a sworn affidavit from the complainant before a claim is investigated. While officers should certainly not be subject to false claims, this affidavit requirement creates a tremendous disincentive to come forward with legitimate claims and keeps hidden serious police misconduct that should be investigated. Until this affidavit requirement can be changed, however, IPRA and BIA should be acting more aggressively to ensure that this requirement does not stand in the way of investigating notorious and sometimes egregious allegations of misconduct. Translation: the police, the city, and everybody else actively encourages citizens not to file complaints. There are tons of videos on YouTube, and photography is not a crime, where citizens want to come in and file a complaint, and they are run through the mills, from everything to there's no such form to the threat of arrest. if they want to follow through on filing a complaint. So I'll leave that to you. Or you just go into photography is not a crime, pinac.com, or photographyisnotacrime.com, and you can take a look at those for yourself. But they're real, ladies and gentlemen. All right, I'm going to jump to page 53. The city does not meaningfully investigate certain types of force unless a misconduct complaint is filed. Okay, well, that basically just speaks for itself. No, I'm not even going to read any of that literature. Okay, this one's, I believe, is important. Attempts to expedite investigations through so-called mediation allow officers to circumvent punishment for serious misconduct. Many serious misconduct complaints that avoid the investigative barriers described above are not fully investigated, but instead are resolved through what IPRA calls mediation, which isn't mediation. All it is you did something super serious, and they knock it down to something that's a little serious, and they'll give you a write-up, or at worst, a day or two off. However, this program is not true police compliant mediation where parties meet to arrive at a mutually agreed upon resolution of their dispute and often gain a better understanding of each other's perspective along the way. Such programs, like the one that has been implemented in conjunction with our consent decree regarding the New Orleans Police Department, provide an opportunity for dialogue and understanding between victims of police misconduct and the officers who are the subject of their complaints in the presence of a neutral third party. Mediation at CPD, however, is a euphemism for a plea bargain and is used in a way that often inappropriately, albeit quickly, disposes of serious misconduct claims in exchange for modest discipline while misleading the public into thinking the accountability has been achieved. Page 54, read the rest of it for yourself. Page 56. Investigations that CPD does conduct are neither complete nor fair. Page 56, read it for yourself. Jumping to page 59. Interviews of officers and civilian witnesses. We identified many cases where investigators failed to take reasonable steps to contact and interview identified civilian witnesses to the incident. For example, in one incident, an off-duty officer shot and wounded a burglary suspect who apparently attempted to wrest the officer's weapon from him. During the struggle, the suspect was shot in the chest and abdomen. However, the suspect also sustained a third gunshot wound to his back, an injury not explained by the officer. A witness canvass identified two residents who reported two large bangs, a pause, and a final bang. The report plainly raised the question of whether the officer fired the final shot, perhaps the unexpected shot to the back, after the threat was neutralized. Yet, IPRA did not interview these two witnesses and instead accepted the officer's account and deemed all three shots justified. Similarly, in one investigation of a complaint of misconduct, an IPRA investigator interviewed an 8-year-old girl who complained that a CPD officer working secondary employment in a school grabbed the girl by her hair, swung her around, and choked her while breaking up a fight in a school hallway. IPRA did not interview the identified student witnesses and entered a non-sustained finding based primarily on the accused officer's written statement. Moreover, in numerous files reviewed, officer witnesses and even the accused officers in misconduct cases were never interviewed. In one misconduct case involving an allegation that officers broke into a home and beat two men, IPRA interviewed a mother and her two children who witnessed the incident and testified in support of the claim. IPRA identified but never interviewed any of the officers involved, discounted the mother's testimony, and ignored the children's testimony because of their ages, and made a not sustained finding. In another case, a man alleged two officers stopped him on the street, slammed him against the car, requiring hospitalization. Although the hospital records supported the injury described and IPRA identified the officers involved, IPRA never interviewed the officers and instead deemed the allegation unfounded because the medical records indicated that the complainant was intoxicated. Officer collusion and witness contamination. One of my favorites. You would think that after the Chicago Police Department knew that the DOJ was coming in and investigating, that they would have gotten smart. I reference you to the Laquan McDonald shooting, where all of the written statements were bullshit. Every last one of them. They, for some reason, didn't realize that there was video all over the place. And after the video was revealed, I'm not saying shown, was revealed that there was video, the city did everything it could to try to keep that video away, both from this investigation and from the citizens of Chicago. All right, let me read the section. Our review of officer-involved shootings and misconduct investigations revealed that IPRA investigators exhibited little interest in whether CPD officers have colluded with each other or have otherwise been subject to contamination. For example, in one case involving an officer who had shot an unarmed man in the back, IPRA reviewed and obtained a copy of video footage from the officer's patrol car that appeared inconsistent with the account the officer had related to CPD detectives immediately after the shooting. IPRA postponed its officer interview for nearly a year while the state's attorney's office reviewed the matter for possible prosecution. Although the incident has become well known throughout the department and the community, IPRA did not ask the officers if they had seen the video or ask them to relate what they had read, seen, or heard about the incident. We found this problem in virtually all officer-involved shootings we reviewed, where IPRA investigators very rarely made any effort to explore the possibility that involved officers and witness officers were lining up their stories or had been influenced by outside information such as video footage or press reports. Instead, officers were given free rein to provide apparently rehearsed accounts with no follow-up questions aimed at ferreting out collusion or contamination. This was true even when the officers used very similar language or otherwise exhibited signs of coordinating their stories. For example, in one case, two officers involved in an officer-involved shooting separately related the incident in nearly identical terms and even included the same digressions at the same point in the narrative. The IPRA investigator never inquired whether the officers had spoken to each other prior to their investigative review or asked them to identify all persons with whom they had discussed. You want to wonder. All right. Hidden witness coaching during officer interviews. IPRA itself undermines the integrity of its investigations by actively enabling officers to receive coaching during the course of an investigative interview. IPRA's investigation procedures manual expressly requires investigators to permit legal representatives to consult with officers about questions and their answers during a recorded interview. In addition, these procedures require investigators to hide the extent of this consulting by turning off the tape recorder whenever officers or their representatives request, even if and often because a critical question is pending. The procedures likewise require investigators not to state on the record who was requesting a pause in the recording, why the request was made, how long the parties were off tape, and not to mention anything that occurred while off tape. In striking contrast, IPRA's procedures for civilian interviews require that time on and off tape be recorded. Although these procedures are limited by their own terms to misconduct investigations, i.e. cases where the officer is accused of specific offenses that may lead to discipline, IPRA applies them in practice to officer-involved shooting investigations as well, despite the fact that in virtually all cases, the officer has not been accused of any particular offense. We found these coordinated coach and conceal efforts reflected in many of the investigations we reviewed. Moreover, we found that it was not uncommon for officers to change the course of the narrative or walk back statements they had made after their legal representatives whispered a few words. Consider, for example, this exchange in an interview of a witness officer. Investigator: okay, do you remember hearing anything that your partner might have said during this whole incident? After you exited the squad car and you positioned yourselves, do you remember hearing your partner saying anything, either commands to the offender or comments to you or anything like that? The officer: I remember hearing my partner say police as he announced his office. Investigator: okay, was that before or after he fired shots? Officer: before. Okay, all right. The union attorney whispers to the client. The officer then says, my partner also stated he has a gun. Investigator: okay, do you remember when he said that? When your partner said that? Officer: inside the dumpster pen. Okay. Union attorney whispers again to the client. As I ordered the offender to put his hands up is when I heard my partner say that. He's got a gun. Absolute coaching from the investigator, absolute changing of the officer's statement after speaking with the investigator. He changed his story. Use of leading and otherwise inappropriate questions. IPRA investigators not only routinely facilitated witness coaching by officers' legal representatives, but at times directly sought to influence officers' statements in the officer's favor by asking unnecessarily leading questions during investigative interviews. For example, investigator: was the victim given a sufficient number of verbal commands to drop his weapon before an exchange of fire ensued? Obvious leading question. Another example: okay, was there time available or a split-second decision to fire your weapon? Officer: it was a split-second decision. Investigator, new case by the way. Investigator: okay, was there time available or a split-second decision to fire your weapon? Officer: yes. Investigator: which one? It was a split second. In another instance, the investigator asked leading questions evidently aimed at eliciting from officers a statement that they feared for their lives when they used deadly force. This line of questioning of an officer who shot an unarmed teenager is illustrative of that point. Officer: when he stumbled to the ground and then he came up, that's what I'm saying. How he jumped the fence. He stumbled to the ground, came up with his hand still in his waistband. That's when I left one round. Investigator: and when he came up, he was facing you? Officer: yes. Okay, so as he was standing back up again, he still had his hands in his waistband. Correct. Investigator: you felt like he had something in his hands. Officer: correct. Investigator: and you were in danger? Officer: yes, I was. I was in fear. I was in fear for my life. Investigator: you were in fear for your life, so you fired how many times? Officer: once. You know, I'm just going to highlight some of this other stuff. Failure to probe officer accounts even when inconsistent with other evidence. Failure to adequately address physical evidence. Lack of appropriate use of evidence from civil and criminal proceedings. Ignoring evidence. Erroneously closing administrative investigations when investigators are unable to prove criminal charges. Superficial investigation documentation and investigative bias in favor of officers. Racial and ethnic disparities in the city's handling of misconduct complaints. IPRA and BIA sustained only 1.4% of all closed complaints from January 2011 through March 2016. It's not surprising, given the deficiencies discussed above, that so few filed complaints were sustained. What these deficiencies do not explain are the racial and ethnic disparities in sustaining complaints of CPD misconduct, particularly complaints of excessive force. Our analysis showed that overall complaints filed by white individuals were 2.5 times more likely to be sustained than complaints filed by black individuals, and nearly 2 times as likely to be sustained than complaints filed by Latinos. 1% of misconduct complaints filed by black residents and 1.4% of complaints filed by Latino residents resulted in at least one allegation being sustained, compared with 2.7% of the complaints filed by whites. A closer Whoops. Hang on one sec. Sorry about that. A closer analysis revealed that the disparity in sustained rates based on the race or ethnicity of the complainant was even greater at the individual allegation level. Black complainants had 2.4% of their individual allegations sustained. Latinos had 3.2% of their individual allegations sustained, and whites had 8.9% of their individual allegations sustained. In other words, for each allegation contained in a complaint, a white complainant is 3.5 times more likely to have the allegation sustained and the officer held accountable for his or her misconduct than a black complainant, and twice as likely to have an allegation sustained than a Latino complainant. Disparities in how IPRA resolves allegations of excessive force are even starker. 2% of all allegations of excessive force involving black complainants and only 1% of such allegations involved against Latino complainants were sustained, as compared to 6% of allegations of excessive force involving white complainants. In other words, whites were 3 times more likely than black complainants to have CPD uphold their allegations of excessive force, and 6 times more likely than Latino complainants to have their excessive force allegations sustained. All right, I'm going to jump to page 72. Investigations lack timely resolutions, undermining the quality of investigations and credibility of the process. There are structural deficiencies causing investigative delays. They're claiming not enough people, but we know that's bullshit. And as a result, investigative delays undermine investigative outcomes and reduce public and officer confidence. That's page 74. Jump into page 77. Tampering with video and audio. Real-time audio and video footage of alleged misconduct is one of the most effective tools in overcoming the code of silence and making credible determinations. Such evidence provides direct insight into what actually took place, has been shown to deter unfounded misconduct complaints, and minimizes the risk of witnesses will later give false statements about the incident, increasing accountability and the public's confidence in the accountability system. Yet CPD has done very little until recently to ensure that police conduct is captured on audio and video. Anybody remember those cops in the Laquan McDonald case that went into the Burger King and deleted all of the video footage regarding the incident? Oh, I'm sorry, they referenced that here. Not until the public release of the McDonald's shooting video captured on only 2 of the 5 car cameras and excluded all related audio has CPD made much effort in ensuring that cameras and microphones entrusted to officers are working properly and are not tampered with. A January 2016 report following the McDonald video release found that the audio capacity of 80% of the department's dash cams was either not working or had been tampered with. The report stated that officers have routinely removed microphone batteries, destroyed antenna, and stashed microphones in the glove compartments of their squad cars. I'm going to let you guys read that, but that next paragraph refers to that Cook County State Attorney Anita Alvarez and her being quote unquote frustrated about the lack of audio. All right, gonna jump to page 79. Complainant and witness intimidation. You know, I'm not going to read that because that pretty much speaks for itself. And finally, I'm going to jump to page 80. The city's discipline system lacks integrity and does not effectively deter misconduct. And you can read that for yourself. Okay, folks, I'm done. That's enough. Hopefully, you will pull the report yourself and go through it so that you are fully informed. I will say that I did not jump to page, actually I'm going to jump to it, page 124, and that has to do with data collection. They don't collect meaningful data, period. Here we go, page 124. Data collection and transparency. CPD's data collection systems are siloed and disconnected. They're cumbersome. They're not coordinated. A lot of the times information is deleted when it shouldn't be. Yeah, it's just one of those, it's what you would expect. That's all I'm going to say about that. So, okay, I'm done. There's quite a bit more in here that if you choose to, you could read for yourself, but it doesn't really have to do with anything absolutely serious, deals with promotion, stuff like that. So hopefully this information has been useful to you. Everybody take care. And knowledge is a weapon. Hopefully this knowledge will be useful to those who have taken the time to watch and listen to it.